fails to give 24 hours notice, and there is any doubt or possibility that it has a fiscal impact, the amendment is out of order. Now, Mr Speaker, that's all we've raised. These standing orders, these Speaker's rulings are here for the House to be guided by, and I think we should get on with our business.
Okay. Let me now rule on the matter which the Honourable Darren Hughes raised, and can I thank him for his expression of respect, and I'll look at taking up the luncheon offer. But I want to correct him on something which I think... Order! Points of order heard in silence. The issue is, which I said, and I want to just clarify again because the member has picked me up wrongly. I said it is not for the chair to rule whether or not something is trivial. When the member was referring to it, he said that the chair said it was a trivial matter, and there is a pertinent difference. I have not ruled whether this is trivial or not. I have simply ruled, as per McGee, that there is reason or the possibility exists, and so therefore I have followed chronologically through that process in determining that. So I have not ruled that it is trivial. Now to the fundamental point that the member made is that the chair can rule out. And I think I'll just pick up Speaker's ruling 119.3 that Mr Brownlee raised. And it's there for good reason, and it is not neutral. And so I think it is just a little wake-up call that where there is a possibility of a fiscal aggregate implication, anyone putting in an SOP simply has to obey the 24-hour rule. And that does not rule out the debate or the possibility at all. So let's now put the questions on Schedule 1. I think we're just about
it's a different point of order because we strongly contest the approach that's been taken. It leaves us with very few rights by way of posing amendments. But if that's the way it's going to be ruled, then we have to try and do our best to advocate and articulate for the people we represent as best we can. But we rely on the protection of the chair for these matters. One of the difficulties, sir, is that the House, as you mentioned before, is an urgency. Urgency is something that was signalled to the opposition very, very late in the piece, far later than is normally the case for the more recent practice under Mr Brownlee's tenure as Leader of the House. This particular amendment was lodged 23 and a half hours ago to create a new Part 3. We did our best to try and comply as best we could with the information we had at the time available to us to put these amendments forward. So there is a point where it is impossible for the opposition to comply with the 24-hour rule if the government behaved or operates in this fashion, that then curtails the ability of the opposition to do that, because as you can appreciate, these are serious amendments. There are three that create three new parts around three important parts of injury prevention. I don't think anyone could argue they are not three serious amendments. Government might not like them, but they're not they're not ridiculous. They're not frivolous amendments. They're proper ones. But we can't, and we have to be able to write those, make sure they comply with the standing orders, get them tabled. And if the ability is not there to do that because the government has moved urgency without that happening...
And that brought this matter up the order paper compared to where it had been.
That's right. This bill was not as high on the order paper as it had been, as my colleague rightly says. It was set down about number 4 or 5. We arrive in Wellington on Tuesday. We're advised that there's going to be an urgency. It becomes number 1. It becomes impossible to comply with the 24-hour rule. So the Leader of the House is losing a lot of time that he need not lose if he was operating slightly differently. It doesn't have to be this way.
That's right, yes.
Let me respond to that and say that the second order... Thank you. The second reading of this particular bill was on the order paper last Thursday, so members could have assumed that it certainly was going to be dealt with and could have applied themselves to the sort of exercise we're in now. But given that's not the case... the final order paper would have been printed by 10:30 on Tuesday morning at the time when caucuses are having their powwows about process or whatever they do in caucuses. And so that certainly was an opportunity. And thirdly, just let me finish. Thirdly, this meets neither the urgency day locked rule or the chronological rule. So it doesn't meet either of those. But the member has raised a point upon which some consideration may need to be given, not at this point, and I would suggest that the Standing Orders Committee, it would be an ideal vehicle for that matter to be teased out, because in this case I can only rule on the rulings and standing orders and other literary record that I have in front of me. Right, we're now going to put the questions, which are that Schedule 1 stand part. Those of that opinion will say aye. Aye. Contrary, no. No. The ayes have it. Party vote called for. The clerk will conduct a party vote.
New Zealand National.
58 votes in favour.
New Zealand Labour.
43 votes opposed.
Green Party.
9 votes opposed.
ACT New Zealand.
5 votes in favour.
Maori Party.
Tokori me whakaheana.
Progressive.
Progressive is 1 vote opposed.
United Future.
1 vote in favour.
The ayes are 64, the noes are 58. Part 2 is... the Schedule 1 is agreed to. The question is that Schedule 2 stand part. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. Party vote. The clerk will conduct a party vote.
New Zealand National.
58 votes in favour.
New Zealand Labour.
43 votes opposed.
Green Party.
9 votes opposed.
ACT New Zealand.
5 votes in favour.
Maori Party.
Tokori me whakaheana.
Progressive.
1 vote opposed.
United Future.
1 vote in favour.
The ayes are 64, the noes are 58, the ayes have it. The question is that clause 1, 2 and 3 stand part. It's a... is this debatable?
Yes.
Oh, it is. So I've got lost track. Honourable David Barker.
Thank you, Mr. Chairman. Amongst the supplementary order papers that are on the table in respect of the title of this bill is a late proposal